Thanks to all of you who have hung in there, and Paul for recording, Vicky and Betsy, Betsy and Lynn and John and a lot of Catherine, a lot of and Bill, my favorites. Now this is Bill's first session here, Bill. I'm not holding you accountable for missing five, but just pointing that out. Yeah, you could have been online, but you weren't. But it's been a nice crowd on the Zoom end of it. Thanks to all of you. It is much appreciated. And your insights and thoughts. I would always tell my students, especially my conservative students and their parents, I'm not trying to turn your children into mini Dr. Pete's, but it is imperative that they learn to think critically and think independently. So my Uncle Joe says is not going to stand up in this class. You have to defend your position on the grounds that support it. And I will not be the same teacher at the end of this year as I am at the beginning of this year, because you students will change me. You will have insights that I don't. And I appreciate those insights. On the other hand, I have insights that you don't. So we will be a group of student and teacher traveling together down the road of education. And I always had at the beginning of the year, there would be a cohort of Republican kids, and they said, Dr. Pete, we're going to turn you into a Democrat or into a Republican. And I said, good luck with that. And they never did, but they were not the same students, and I was not the same teacher at the end of the school year.
Little mind.
Well, I really tried to be fair. Every paper I had them write, and each student wrote 65 papers during the school year. So I had to be a fast reader. But every one of them, every issue we looked at, we had an article on one side and an article on the other. And you read both of those. And the teacher that replaced me, who turned out he was very conservative. We had words over going to war in Iraq. And he told me a couple of years ago, he says, we bitterly opposed each other on it, but you were right. It was wrong from the get-go. And I had told him, I said, Jim, and he was a great teacher. I said, you may be a conservative now, but you cannot teach advanced placement government and stay as conservative as you are. You will move to the left, whether you like it. You won't become a Democrat, but you will not be a conservative Republican by the time you have taught this course for 4 or 5 years. And he said, when you predicted I couldn't, and he said, you were absolutely right. You just can't do that. So John Kendall has proposed a new question that I thought was an excellent question. So we're going to start as we have in the past several meetings, 2 meetings, this is the third one. Here's the premise. The United States Supreme Court has ruled that the Trump administration is no longer responsible to oversee the July 4th, 250th anniversary of the Declaration of Independence. You are appointed to a team responsible for efficiently and cheaply engaging the U.S. population in the reading and significance of the Declaration of Independence. Would you encourage public readings? 100% I would. It's hearing it sometimes makes all the difference in the world, and you need to hear it spoken out loud to say, okay, I need to think about what are these words actually mean. So I call this the struggle to find meaning in the words of a 250-year-old document. So let's start there. So the 250-year-old document obviously is the Declaration of Independence. On July 4th, 1776, we hold these truths. No, we're not arguing about whether they're truthful or not. They are truths to be self-evident, so obvious that you don't have to point out that they are truths, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. Now we're going to go back to March the 31st, 1776. and a lady by the name of Abigail Adams. And yes, she was John Adams' wife. She writes to her dear husband, who is at the Second Continental Congress. She knows what they are debating about, and she says, "Remember, all men would be tyrants if they could. If particular care and attention is not paid to the ladies, we are determined to foment a revolution, a rebellion, and will not hold ourselves bound by any laws in which we have no voice or representation."
You're here.
He just blew her off, by the way. But that wasn't the only thing she pointed out.
He's a guy.
He says, his response was something that, oh, the petticoats always command the attention of men, blah, 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 blah. But Abigail also noted that in this same letter, "I have sometimes been ready to think that the passion for liberty cannot be equally strong in the breasts of those who have been accustomed to deprive their fellow creatures of theirs. Of this I am certain, that it is not founded upon that generous and Christian principle of doing to others as we would that others should do unto us." So here she's taking what are the two critical issues? America's original sin, some might say, how women were treated, and the issue of slavery. So here she is identifying those two things before the Declaration is even written and pointing them out. On July the 2nd, so some critical dates we got to come up here. On July the 2nd, independence is declared. On that day, John Adams said, "The 2nd day of July, 1776, will be the most memorable epoch in the history of America. I am apt to believe that it will be celebrated by succeeding generations as the great anniversary festival. It ought to be commemorated as the day of deliverance by solemn acts of devotion to God Almighty. It ought to be solemnized with pomp and parade, with shows, games, sports, guns, bells, bonfires, and illuminations from one end of this continent to the other, from this time forward forevermore." Wrong date, but on July 4th, the Declaration of Independence is unanimously adopted. And by unanimously, I mean all 13 colonies, because they voted by delegation. That doesn't mean that all the delegates there were in favor of independence, because they weren't. But on each state delegation, there was a majority. So when they say it was unanimously adopted, that's what they mean. Approximately 200 copies of the Declaration of Independence, known as the Dunlop Broadsides, were printed by John Dunlop on the night of July 4th, 1776, for distribution throughout the colonies. These were the first official copies, with only 26 of the more than 200 surviving today. On July the 6th, one of those printed copies was first read in public in Philadelphia. So 2 days after July 4th, it's read in public. And sometime not terribly long after that, George Washington would have a copy that he would have read to his soldiers. On August the 2nd, the signing of the famous engrossed copy. Now, what does that mean? That means it's written with large formal script. That's the copy that is on display in the Washington, D.C., is that engrossed copy. The signing begins. It doesn't end, there are 56 signers. It doesn't end until late 1776, early 1770, probably January 1777, before everybody that was going to sign it signed it. Of course, beginning with John Hancock in very large script, so even the dim-witted, poor-sighted George III could see who signed it. So, and plus, John Hancock had a very big ego. So you had that going for him too.
Yeah.
Now, on July the 19th and 20th, 1848, Elizabeth Cady Stanton revealed her Declaration of Sentiments. And what she wisely did was mimicked almost word for word what the Declaration of Independence said. So she said, when in the course of human events, it becomes necessary for one portion of the family of man to assume among the people of the earth a position different from that which they have hitherto occupied, but one to which the laws of nature and nature's God entitle them, a decent respect to the to evident
Oh my
that
goodness.
all men and women are created equal, that they are endowed by their Creator with certain inalienable rights, that among these are life, liberty. Now, where the Declaration of Independence, laundry list of complaints against King George III, here's what was in the Declaration of Sentiments instead. The history of mankind is a history of repeated injuries and usurpations on the part of man towards woman, having in direct object the establishment of an absolute tyranny over her. To prove this, let facts be submitted to a candid world. He has never permitted her to exercise her inalienable right to the elective franchise. He has compelled her to submit to laws in the formation of which she had no voice. He has withheld from her rights which are given to the most ignorant and degraded men, both natives and foreigners. Having deprived her of this first right as a citizen, the elective franchise, they're leaving her without representation in the halls of legislation. He has oppressed her on all sides. He has made her, if married, in the eye of the law, civilly dead. And you go on to a whole laundry list of very legitimate concerns that women had had, but had been unwilling to speak up about them. So this was done in Seneca Falls, 1848, and that begins the movement for women to achieve the right to vote. That's the first step, and she's made it clear. If we have the voting franchise, we can participate in the laws which are going to affect us. And we can change those laws so that women are treated equally. Now it's going to take, 1848, it's 1920 before the 19th Amendment is ratified. So a long time, and Elizabeth Cady Stanton is not going to live to see that, but her daughters do. And they have in several magazines, they create the idea of Trumbull's painting, I think it is, of the signing of the creation of the Declaration of Independence, except it's all women. Elizabeth Cady Stanton is there, Lucretia Mott, Susan B. Anthony. So she builds the painter builds this picture that mimics Thomas Jefferson handing over the Declaration of Independence, except in this case, it's the Declaration of Sentiments that's being remembered. 1852, July 5th, Frederick Douglass. What to the slave is the 4th of July? I say it with sad sense of the disparity between us. I am not included within the pale of glorious anniversary. Your high independence only reveals the immeasurable distance between us. The blessings in which you this day rejoice are not enjoyed in common. The rich inheritance of justice, liberty, prosperity, and independence bequeathed by your fathers is shared by you, not by me. The sunlight that brought forth light and healing to you has brought stripes and death to me. This 4th of July is yours, not mine. You may rejoice, I must mourn. On March the 6th, 1857, Roger B. Taney, Chief Justice of the United States, in the Dred Scott versus Stanford decision. We think, and it's in brackets here, people of African ancestry are not included and were not intended to be included under the word citizens in the Constitution, and can therefore claim none of the rights and privileges which that instrument provides for and secures to citizens of the United States. They had for more than a century before been regarded as beings of an inferior order and altogether unfit to associate with the white race, either in social or political relations, and so far inferior that they had no rights which the white man was bound to respect, and that the Negro must justly and lawfully be reduced to slavery. Lincoln hated that decision. And now he basically said, I'm going to protest it, but I'm not going to act illegally. The court has made its decision. But he said, I might note, it wasn't a unanimous court. Two dissenters wrote blistering dissents that grabbed the attention of newspapers of the time and basically said, Taney is lying. Everything he said here is not true. He has twisted the truth into something that is absolutely untrue, and we cannot let that stand forever.
Tom,
Yes.
the justices were there at that time.
7 or 8, I don't think 9 in 1857. And I'm pretty sure it's not 10. But yeah, so it was lopsided. All the slaveholding justices were lined right up with Roger B. Taney, and 2 of the slaveholding that didn't hold slaves wrote dissenting opinions. Lynn.
Yeah, I don't want to be too cynical, but I guess I will be. So
I would expect nothing less of you, Lynn.
If the phrase all men are created equal didn't include women and didn't include people of African descent, and had there been maybe Asian people, maybe not them.
Oh, they were excluded too.
So men
Right.
is not seen as large, inclusive. It's seen as when you're like us, you get to vote.
Yeah.
All the people like us.
Yeah. Property owning white men.
Right. So it's not the legal or dictionary, Oxford definition of men. It's people that are like us.
Right.
Are included.
Here's that's a very, very good point. Here's the problem with the logic. About 20% of the soldiers who were present with George Washington at the surrender in Yorktown were African American. So we have that problem. There were a number of states where free property owning African Americans had the voting franchise.
Oh, so they were voting.
They were voting
From the start of the,
prior to the convention, the Declaration of Independence being written, they had the voting franchise in New York, Massachusetts, Connecticut, Rhode Island. So a number of the New England states, and I think Pennsylvania. So they could vote, and they did vote.
They made throughout history from that period of time forward, they always could vote.
No, because unfortunately, some of the states grew very restrictive and made it very difficult for African Americans. They set a property level that many could not meet. And in other cases, they simply voted away the voting franchise. But at the time the Declaration was written, the country was far more progressive in some ways than it was later when under John C. Calhoun, where he's saying slavery is a positive good, except if you're a slave, of course. Yeah. Yes.
So some white men who did not own property,
Not vote. That's correct.
they
Right.
set the standard high.
Well, in some cases, they sent it high to make it difficult for African Americans to hold enough property to vote. But they were also excluding a lot of white people, white men at the same time. And of course, all white women and all black women. On February the 22nd, 1861, George Washington's birthday, I might note, Abraham Lincoln was at Independence Hall. He was on his way to Washington, D.C. for his inauguration. He said, I am filled with deep emotion at finding myself standing here in this place where were collected together the wisdom, the patriotism, the devotion to principle from which sprang the institutions under which we now live. You have kindly suggested to me that in my hands is the task of restoring peace to the present distracted condition of the country. Those words resonate very well with us today, present distracted condition of the country. I can say in return, sir, that all the political sentiments that I entertain have been drawn, so far as I have been able to draw them, from the sentiments which originated and were given to the world from this hall. I never had a feeling politically that did not spring from the sentiments embodied in the Declaration of Independence. So here he is on the way to Washington, D.C. to be inaugurated, almost assassinated, for those of you that know, in Baltimore. For those of you that know, they had to sneak him through Baltimore.
Wow.
Yeah, it's called, pick up a book, it's called The Baltimore Plot. And it's ironclad. They are going to kill him. They had it all figured out. Yeah, and Pinkerton was one. There were actually two. The source of that information came from two completely different sources. Pinkerton was one of them. And I'm trying to think what the.
So did Pinkerton, were they one of the instigators or did they ferret out the?
Well, they were the ferreter. They were the spies in Baltimore that determined Secret Service in effect. Right. And yet there was another lady who coming through the South and through Baltimore heard exactly the same thing. So William Seward, the Secretary of State to be, sent his son Frederick up to warn Lincoln, and he caught up with them at the same time Pinkerton did. So from two completely separate sources came the same information. There's a plot to kill you in Baltimore, and it's real. And Lincoln believed, and correctly believed, that he was in great danger. So they sneaked him on a single railroad car, on a train that held one great passenger, Abraham Lincoln, and then they connected up in Baltimore, because the way Baltimore was, the railroad didn't go through Baltimore. You had to take the railroad car and detach it from the train and pull it on a separate set of railroad tracks by horse through the city, and then at the other end of the city, reconnect it to a new locomotive, and nobody else other than the Pinkerton men and woman. There was a woman who was a Pinkerton agent, and she was the one that actually made sure that Lincoln was safe.
Why has this not been a movie?
That is a good question.
I saw it in something.
Yeah.
It's just in some part of the movie. I have
Yeah.
the name of the book.
March 21st, 1861. Alexander Stevens, a friend of this guy from Illinois called Abraham Lincoln, served in Congress the same time that Abraham Lincoln did, elected vice president of the Confederate States of America, delivered this speech, part of which read, "Our new government is founded upon exactly the opposite idea. Its foundations are laid, its cornerstone rests upon the great truth that the Negro is not equal to the white man, that slavery subordination to the superior race is his natural and normal condition. This, our new government, is the first in the history of the world based upon this great physical, philosophical, and moral truth." November the 19th, 1863, 77 years ago, our fathers brought forth on this continent a new nation, conceived in liberty and dedicated to the proposition that all men are created equal. Notice he didn't say self-evident truth, something that was so obvious that we didn't have to prove it. What Lincoln is now recognizing in the midst of a civil war, of which he knew that slavery was the cause, that it was now a proposition, something that had to be proved, that all men were created equal. So then we have 4 more years that we need to highlight. 1865, the 13th Amendment, banning slavery forever. 1868, the 14th Amendment, among other things, birthright citizenship, which is going to be argued next week before the Supreme Court. 1870, the 15th Amendment, the right of African American men to vote, but no women, especially not Black women. You're not going to see that till 1920 and the 19th Amendment. At that point, finally, women will be given what they should have had all along as equal citizens of the United States of America. So our definition of men was white men, Black men, white and Black women, mankind finally. So these are the words, all men are created equal. What does it mean? We're still debating that. So on the 250th anniversary of this great and important document, in a time of turmoil and a great partisan divide, let us reread the words of the Declaration of Independence and find in them a new birth of freedom for immigrants, minorities, and women.
Well said.
So that's how I would to answer your question, John. That's how I would introduce them.
Outstanding.
We still
And-
don't have equal rights, ladies.
No, you don't. You don't.
Do not.
Until you control your own bodies, among other things, you don't have
There are
equal
laws
rights.
specific to respecting women's rights. There are still laws that are enforceable.
Yes, on the books, there are a lot of laws on the books that nobody enforces. Yes, sir.
When did Native American men and women get the right to vote?
In the ninth, they were allowed to be United States citizens about 1926, I think.
24.
Somewhere in that. It was when they became American citizens. Now, is there still discrimination? Well, you see ICE picking up indigenous peoples and deporting them, forgetting that these are the original American citizen, you dopes. But, what can I say? ICE just freezes my soul in the way that they act.
So where's ICE sending these indigenous people?
Well, we don't know all the places. That's the thing that during the Bush administration, remember we had those black ops sites?
Oh, yeah.
Yeah. And we didn't know where they were because we were never told where they were. And we don't know where all of them were at this point. We have a pretty good idea for some of them. So we don't know. In some cases, they're shipped off to not Nigeria, but South Sudan, I think. Yeah, where you don't know the language, you have no culture, you're just lost, and you will disappear, and no one will ever be able to find out where you were deposited. It's disgusting.
And that was just upheld too.
Yes,
By the
yeah,
court.
by what's called the shadow docket of the Supreme Court, which means that the Supreme Court makes a decision, but it's not argued in public, and you have no idea what the logic of the decision was and what the legal reasoning is, because more often than not, there is no legal reasoning, no legally justifiable reason on. So since we're mentioning the Supreme Court, we might actually now turn to Federalist 78. And notice I put the judicial department. And so we will see that the question is, the propriety of the court is not disputed. He will start off with saying, we're not going to discuss whether it's the right thing to have the court. It is. We'll talk about how it works. There are some things that might be questioned, and I'll deal with those, but I'm not going to deal with whether or not we should have a Supreme Court. We need one. We must have it. because other than that, there are certain issues that we can never resolve. If you have states in legal disputes with each other, and each state Supreme Court's going to stand up for the state. You need a arbiter between them, and the Supreme Court is going to be that arbiter. So he says, to the people of the state of New York, we now proceed to an examination of the Judiciary Department of the proposed government. In unfolding the defects of the existing confederation, the utility and necessity of a federal judicature have been clearly pointed out. It is the less necessary to recapitulate the considerations there urged, as the propriety of the institution in the abstract is not disputed. Every state had a Supreme Court, a court that resolved issues in that state. They had a state court of the highest appeals. So we say, we're just mimicking that, except it has to be able to do more. The only questions which have been raised being relative to the manner of constituting it and to its extent. To these points, therefore, our observations shall be confined. So we're talking about what is disputed, the manner of constituting the court. How do we create it? Who do we put on it? Who puts it on? And who approves that? And the extent of the court's power. Just how far into this new government and into how the Constitution operates are we going to allow the court to make decisions? Is there going to be a limit on that we place on the court on things that it can't decide upon? And what happens if you have a law in a state that appears to be unconstitutional? Who's going to decide that? So it says, it seems to embrace these several objects. First, the mode of appointing the judges. That's here. The tenure by which they are to hold their places. That's the second. And the partition of the judiciary authority between different courts and their relations with each other. And in this case, that means several things. It means between the state Supreme Courts and the United States Supreme Court, or the federal courts and the federal district courts. That's the lowest level of federal courts, and those would exist almost from the get-go, decided by Congress. And then, does the Supreme Court have the authority to overrule a federal district court? Now, at the beginning, we now have 3 tiers of federal courts. You have your district courts. I think there are 93 of them. Don't hold me to that, but I'm pretty close. And then you have courts of appeals, and those range into 13 districts. And then you have the United States Supreme Court that sits over those. So like 93, 13, 1. And are there things that the Supreme Court cannot rule upon? Yes, we'll get to those. So he says, first, as to the mode of appointing the judges, this is the same with that of appointing the officers of the Union in general, and has been so fully discussed in the last 2 numbers that nothing can be said here which would not be useless repetition. Well, since we didn't go to the 2 previous ones, so we don't have a useless and needless repetition, it's the executive branch, the president, that nominates, and the Senate that confirms. So you have all 3 branches interacting with each other in this nominating, conferring, confirming, and acting. Second, as to the tenure by which the judges are to hold their places, this chiefly concerns their duration in office, the provisions for their support, the precautions for their responsibility. So they knew that these judges needed to be very qualified and that they had to be persons of virtue. Which, as Montesquieu had defined it, was putting your country above your personal ambitions, your country above party. According to the plan of the conventions, all judges who may be appointed, and that's all federal judges, in the United States are to hold their offices during good behavior, which is conformable to the most approved of the state constitutions, and among the rest, to that of this state. So he's saying, we do it in New York. We're proposing to do exactly what we do in New York. And of course, he's speaking to the state of New York. Its propriety having been drawn into question by the adversaries of that plan, is no light symptom of the rage for objection, which disorders their imaginations and judgments. So he's kind of slurring them here a little bit, saying they're stupid. The standard of good behavior for the continuance in office of the judicial magistrate is certainly one of the most valuable of the modern improvements in the practice of government. In a monarchy, it is an excellent barrier to the despotism of the prince. In a republic, it is no less an excellent barrier to the encroachments and oppressions of the representative body. Remember, their chief concern was the power of the legislature, unlike what we're seeing in action today. They said the legislature is elected by the people, so theoretically, the power of the people is closest to the representative branch. That's the one we've got to be very careful of and make sure that, because it can oppress. And it is the best expedient which can be devised in any government to secure a steady, upright, and impartial administration of the laws. Whoever attentively considers the different departments of power must perceive that, in a government in which they are separated from each other, the judiciary, from the nature of its functions, will always be the least dangerous to the political rights of the Constitution. And theoretically, that's probably true. But oftentimes we don't think of that as true because we live in abnormal times, unfortunately. So he says the judiciary has no influence over either the sword or the purse. So they don't have an army, and the legislature, that's the president, and the legislature controls money. So the judiciary has no access to either of those, no direction either of the strength or of the wealth of the society, and can take no active resolution whatever. It may truly be said to have neither force nor will, but merely judgment, and must ultimately depend upon the aid of the executive arm, even for the efficacy of its judgments. As Andrew Jackson was alleged to have said, which he probably didn't, when the Supreme Court ruled against him in the case of the Seminole Indians, ruled in favor, Jackson's allegedly said to the Supreme Court, "You've made your decision, now enforce it," which they couldn't. So here you have these Native Americans who had become Christianized, civilized citizens, but because of who they were, Jackson saw them as a threat. And besides that, some white people wanted their land to farm on. So you have those issues. The simple view of the matter suggests several important consequences. It proves incontestably that the judiciary is beyond comparison the weakest of the three departments of power. It can never attack with success either of the other two, and that all possible care is requisite to enable it to defend itself against their attacks. We're beginning to see some of that, whenever Trump goes to the media and complains about the decisions, and he says, they're traitors. You put 3 of them on the court, Mr. President, 2 of whom just ruled against you on the tariffs. And they're traitors. So it's, what have you done for me today? So long as the judiciary remains truly distinct from both the legislature and the executive. For I agree that there is no liberty if the power of judging be not separated from the legislative and executive powers. And that was a deliberate quote from Baron de Montesquieu in The Spirit of the Laws. And it proves in the last place that as liberty can have nothing to fear from the judiciary alone, but would have everything to fear from its union with either of the other departments, that is, all the effects of such a union must ensure from a dependence of the former on the latter, notwithstanding a nominal and apparent separation, that as, from the natural feebleness of the judiciary, it is in continual jeopardy of being overpowered, awed, or influenced by its coordinate branches. And that as nothing can contribute so much to its firmness and independence as permanency in office. This is why he's saying it must be a lifelong appointment, because that helps insulate from corruption. It doesn't completely insulate from corruption, but it helps to insulate. And in a great measure, as the citadel of the public justice and public security. The complete independence of the courts of justice is peculiarly essential in a limited constitution. By a limited constitution, I understand one which contains certain specified exceptions to the legislative authority, such, for instance, as that it can pass no bills of attainder, meaning that you are declared that you're guilty and you are sentenced without a trial. It's like monopolies, go directly to jail, do not pass go. That's the idea of a bill of attainder. Or no ex post facto laws. In other words, trying you for something that was legal at the time you did it, but has been made illegal since. Congress is forbidden to pass ex post facto laws. And the like. Limitations of this kind can be preserved and practiced no other way than through the medium of courts of justice, whose duty it must be to declare all acts contrary to the manifest tenor of the Constitution void. So, who, according to Hamilton, has the right to strike down the laws of Congress? The Supreme Court does. He said, who else is going to do it but this Supreme Court of the United States? Such perplexity, without this, the reservations of particular rights and privileges would amount to nothing if you cannot strike down bad laws. What is to protect the citizens? Some perplexity respecting the rights of courts to pronounce legislative acts void, because contrary to the Constitution, has arisen from an imagination that the doctrine would imply a superiority of the judiciary to the legislative power. It is urged that the authority which can declare the acts of another void must necessarily be superior to the one whose acts may be declared void. As this doctrine is of great importance in all the American constitutions, a brief discussion of the ground on which it rests cannot be unacceptable. I love his double negative. There is no position which depends on clearer principles than that every act of a delegated authority, contrary to the tenor of the commission under which it is exercised, is void. No legislative act, therefore, contrary to the Constitution, can be valid. So that means wherever that law is written. So a state cannot say that we passed it and that's true of this state, but it's contrary to the Constitution, but you can't do anything about it. He's saying, that's not the way it works. The federal court can and should and must declare acts contrary to the Constitution, null and void, no matter where they originate, whether it's at the state level or at the national level. That authority applies to both. To deny this would be to affirm that the deputy is greater than his principal, that the servant is above his master, that the representatives of the people are superior to the people themselves, that men acting by virtue of powers may do not only what their powers do not authorize, but what they forbid. If it be said that the legislative body are themselves the constitutional judges of their own powers, and that the construction they put upon them is conclusive upon the other departments, it may be answered that this cannot be the natural presumption, where it is not to be collected from any particular provisions in the Constitution. It is not otherwise to be supposed that the Constitution would intend to enable the representatives of the people to substitute their will to that of their constituents. It is far more rational to suppose that the courts were designed to be an intermediate body between the people and the legislature in order, among other things, to keep the latter within the limits assigned to their authority. The interpretation of the laws is the proper and peculiar province of the courts. So he's saying it over and over again. Who does it make sense? Ought to determine what laws are and are not constitutional. He says it has to be the courts. If there should be a constitution, is in fact, and must be regarded by the judges as a fundamental law. It therefore belongs to them to ascertain its meaning, as well as the meaning of any particular act proceeding from the legislative body. If there should happen to be an irreconcilable variance between the two, that which has the superior obligation and validity ought, of course, to be preferred. Or, in other words, the Constitution ought to be preferred to the statute, the intention of the people, to the intention of their agents. Nor does this conclusion by any means suppose a superiority of the judicial to the legislative power. It only supposes that the power of the people is superior to both, and that where the will of the legislature, declared in its statutes, stands in opposition to that of the people, declared in the Constitution, the judges ought to be governed by the latter rather than the former. They ought to regulate their decisions by fundamental laws rather than by those which are not fundamental. This exercise of judicial discretion in determining between two contradictory laws is exemplified in a familiar instance. It not uncommonly happens that there are two statutes existing at one time, clashing in whole or in part with each other, neither of them containing any repealing clause or expression. In such a case, it is the province of the courts to liquidate and fix their meaning and operation, so far as they can by any fair construction be reconciled to each other. Reason and law conspire to dictate that this should be done where this is impracticable, that's one of their favorite words. It becomes a matter of necessity to give effect to one in exclusion to the other. The rule which is obtained in the courts for determining their relative validity is that the last in order of time shall be preferred to the first. So newer laws should be preferred to older laws. And I suppose there are many laws in the state of Washington that are still literally on the books and in effect that would appall us. But they've been superseded, this situation here, they've been superseded in practice by newer laws, but have never been taken off the books. And that leads to what happened in the state of Wisconsin over abortion, where they went back to like an 1870 or 60 something law and tried to pretend that that meant exactly what it was assumed that it would mean today. And fortunately, that got overruled. But this is a mere rule of construction, not derived from any positive law, but from the nature and reason of the thing. It is a rule not enjoined upon the courts by legislative provision, but adopted by themselves as a consonant to truth and propriety for the direction of their conduct as interpreters of the law. They thought it reasonable that between the interfering acts of an equal authority, that which was the last indication of its will should have the preference. But in regard to the interfering acts of a superior and subordinate authority, of an original and derivative power, the nature and reason of the thing indicate the converse of that rule as proper to be followed. They teach us that the prior act of a superior ought to be preferred to the subsequent act of an inferior and subordinate authority. And accordingly, whenever a particular statute contravenes the Constitution, it will be the duty of the judicial tribunals to adhere to the latter and disregard the former. So when it comes to constitutional issues, the Constitution trumps everything. And I didn't mean to do a little.
Yeah.
Yeah.
It's sad that he
It's
had
sad.
that name.
Yes, it is. It can be of no weight to say that the courts, on the pretense of repugnancy, may substitute their own pleasure to the constitutional intentions of the constitutional intentions of the legislature. This might well happen in the case of two contradictory statutes, or it might as well happen in every adjudication upon a single statute. The courts must declare the sense of the law, and if they should be disposed to exercise will instead of judgment, the consequence would be equally the substitution of their body. The observation, if it prove anything, would prove that there ought to be no judges distinct from that body. If then the courts of justice are to be considered as the bulwarks of a limited constitution against legislative encroachments, this consideration will afford a strong argument for the permanent tenure of judicial offices. So he is long building this case that why are the appointments to the federal judiciary lifetime appointments? Because you need that for protection, among other things. This independence of the judges is equally requisite to guard the Constitution and the rights of individual from the effects of those ill humors which the arts of designing men or the influence of particular conjunctures sometimes disseminate among the people themselves, and which, though they speedily give place to better information and more deliberate reflection, have a tendency in the meantime to occasion dangerous innovations in the government, which applies precisely to what we see happening right at the moment. In the government, and serious oppressions of the minor party in the community. That sentence means a lot.
So what does it mean? What is that sentence?
What he is arguing is that the purpose of the court is to protect from could be novel introductions that are contrary to the Constitution. So it's imperative that these judges be permanent appointments so they are less likely to be corrupted by those new influences that may be harming individuals or classes of people in the society. That's the idea. While I trust the friends of the proposed Constitution will never concur with its enemies in questioning that the fundamental principle of Republican government, which admits the right of the people to alter or abolish the established Constitution whenever they find it inconsistent with their happiness. And so altering is amending. And at this point in time, we have 27 amendments to the Constitution. And they initially only fixed mechanical. The first two amendments to the Constitution, the first 10 were rights. The next two were technical flaws in the Constitution that had to be fixed. And then we get to the 13th, 14th, and 15th. We're now mandating social changes, fixing social problems, and only going a little bit in the sense of declaring slavery unconstitutional. It's never going to happen again. Talking about birthright citizenship, the question, are African Americans or are they not citizens of the United States? They were born here in the United States. They are citizens. And that went for anybody. You know, if a alien couple had a child in the United States, the 14th Amendment says that you may not be parents, you may not be American citizens, but your child born on American soil is an American citizen. As well as if you are American citizens and you are on a base in Germany and you have a child, that because you are both American citizens, that child is an American citizen. If the mother is an American citizen, the child is an American citizen. If the father is an American citizen, which was a serious problem in the children of Vietnam, there are many children in Vietnam that had American, those children were citizens as well.
Wow.
So they're here. Now I got to find out where I was here. Okay. Until the people have, by some solemn and authoritative act, annulled or a challenge or changed the established form, it is binding upon themselves collectively as well as individually, and no presumption or even knowledge of their sentiments can warrant their representatives in a departure from it prior to such an act. But it is easy to see that it would require an uncommon portion of fortitude in the judges to do their duty as faithful guardians to the Constitution. And I think that's all I've ever asked of the justices is to be faithful guardians of the Constitution, where legislative invasions of it had been instigated by a major voice in the community. But it is not with a view to infractions of the Constitution only that the independence of the judges may be an essential safeguard against the effects of occasional ill humors in the society. These sometimes extend no farther than to the injury of private rights of particular classes of citizens by unjust and partial laws. Here also, the firmness of the judicial magistrate is of vast importance in mitigating the severity and confining the operation of such laws. But to that I add, if you look at the history of the Supreme Court of the United States, the Supreme Court almost never acts in a crisis in the way that bends the arc of justice.
Wait, say that again.
I said, if you expect a Supreme Court in a time of great trouble to be your savior, I'm going to tell you it's not likely to happen. The track record of the Supreme Court over and over and over again is to do the unjust thing, and in a decade, sometimes more, fix the problem later. So let's take a couple of examples. 1857, the Dred Scott decision. Blacks are not white, therefore they can never be citizens of the United States. That was a major decision that pushed the United States closer to civil war. Had Justice Taney, he had an option to do what he could have simply, the court could have simply ruled against Dred Scott and said, in your case, sir, you were a slave, you were taken to free territory for a period of time, but that did not qualify you to become an American. He could have limited the scope of the decision, where it would have made Dred Scott mad and his lawyers mad, but probably wouldn't have inflamed the population of the North, which was a direct consequence. This abolitionism went into high gear after that, and Americans began through the Underground Railroad to act to get African Americans out of the United States and to Canada. So, and that was illegal to do that. And also, those slaves had no say so. They couldn't defend themselves. They got no due process. So when we see the lack of due process in immigrants, illegal aliens, their people, being shipped out without due process, without being seen by a judge, according to the 14th Amendment, that is unconstitutional. Yes, Lynn.
So I know I'm going to ask your opinion, but you just have so much more background than I do. So if Supreme Court justices have, they're appointed for life, why would there almost always be the case that when faced with a crisis, they go conservative, like let's do the status quo or whatever?
Or how about Americans of Japanese descent?
So what's the impetus that causes them to go backwards or stay the course than to move forward? Do you have an opinion?
I do, and I think it's because judges, by their very nature, tend to be conservative people. That because they are tasked with preserving the Constitution, and that almost inherently is a conservative measure, and they cannot see the consequence, the injustice. They have to know they have to have a sense of injustice, but they're saying, well, in the case of World War II, we're scared of the Japanese spies, and we can't trust a single American of Japanese descent because they're all spies. I mean, it was all lies. It was all made up. And yet the Supreme Court upheld it in Korematsu. And actually, Korematsu, the decision itself has never been formally overturned, to my knowledge. He was given, he was freed from the consequences of that legal decision, but only at the state level of courts did the state courts agree that, yeah, this was illegal, it was improper, it was unjust, and we apologize. And that was 40 or 50 years after the fact. It's a long run before that. So we take a look, how about trying people in military courts? That was an issue in the Civil War. It became an issue after 9/11, where suddenly citizens, or even terrorists still have the right to be seen in court, but they were simply put in prison without due process. Again, it's an issue. It's what makes us Americans, is trying to hold the standard for everybody, failing miserably over and over again.
Maybe in the large art, we make progress.
Well,
Large art.
I do. It was Martin Luther King has said, the arc of the moral universe is long, but it bends towards justice. But what he didn't say, which I think is extremely important and why you are so important, is who bends it.
Yep.
The courts don't bend it. It's you and I that bend it towards justice, because we stand up for what we believe in and are willing to go out and protest and be on the streets and get flipped off by 1 or 2% of the people that drive by us. Yes.
So I just have an example, maybe helpful. So in my classes, I used to walk in, at that particular time, I wanted to teach this topic. And I'd walk in just a little bit late, they're all graduate level classes. And I'd say, give me 4 instances of something that fundamentally changed any society. And now I would have to say other than technology, at that point. And whatever they said, I wrote up on the board. And then I'd say, what was the impetus for this? What was it? It was always a societal change that started from the bottom, or at least came from the bottom, and worked its way up to law. And I could just count on it. It's like the women's vote, the loss of apartheid in South Africa, whatever they said, all over the world. I could almost pretty much, I always counted on, I always worked, that it started from a movement of people. I thought it was interesting.
That people ultimately are the ones that make the difference. But it's slow and it's long.
It's that long arc.
It is that long arc. Yes.
Well, in the court system, until you get to the Supreme Court, the jury system will move the court toward.
It can, towards justice, you would hope,
Yeah.
because it is a court of your peers. And sometimes, some courts, when you do jury selection, they try and select jurors that are maybe not particularly bright, so that they can. So, I've never served jury duty yet, and I've been available for years and years and years. Now, my wife Georgia has been on at least 3 juries, I think. Now, including your statement. Yeah. Yes, but me, no, I don't serve on a jury.
Yeah.
What?
I just had my name. She's just tossed in there.
Is she one of those not particularly smart people?
Oh, no. She's one of the ones that they don't want on a jury, but yet she has managed, for whatever reason, to be on 3 juries, and I've been on none. And I've been a registered voter for how many more years? And you have a lot.
6 months.
6 more years.
That's because she's a woman.
And she is smart. She is a smart woman. I've learned. I've had to learn to trust her judgment, but I do.
So this reminded me of 2 quotes relative to her thing. Margaret Mead saying, "Never doubt a small group of people can change the world. Indeed, it's the only thing that ever has." or something to that effect.
Yeah, that's about right.
And the other thing was Winston Churchill. America can always be relied on to do the right thing only after having exhausted all other possibilities.
Right. Exactly. And that's America. And he also said, democracy is the worst form of government, except for all the others. Churchill, but yeah, or to the one that a woman said, if you were my husband, I would give you poison. He said, if I were your husband, I would drink it. He had a tart way of saying things.
Those British.
That inflexible and uniform adherence to the rights of the Constitution and of individuals, which we perceive to be indispensable in the courts of justice, and certainly not to be expected from judges who hold their offices by a temporary commission, meaning elected judges are not a great idea. And I do get that, because what inevitably happens is as it was in Ohio, where almost all the judges are elected, it becomes political. It's not, and that's where Hamilton was saying, this is why we make it permanent, because we are looking for character, for virtue in these judges, and you won't necessarily get it by the elective process. What you will get is popular. What you will get is what you paid for.
Mhm.
So, but you might not necessarily get a fine legal mind, and that's the thing that you need.
Well, I'll have.
Okay, see,
Washington has an interesting thing that with our Supreme Court, that the year they turn 70, they have to then retire.
yes.
So we have, Johnson will be finishing his term
Mm-hmm.
because he turned 70, and we will have, I think, 5 people to be elected on the Washington Supreme Court
Mhm.
this year. And talking politically, Ferguson has been able to appoint 2 people already, and those will be contested seats if somebody wants to run against those 2. But again, what you're saying as far as political, our Supreme Court by ballot, what's that called, Ballotpedia, is rated kind of moderately
Mm-hmm.
left. But I suppose
Well-
others might characterize them differently.
Yeah, I generally don't like it. In Ohio, it's when a Supreme Court Justice of Ohio turns 70, they can't be reelected again. So if they were elected at 69, then whatever time that goes on, they can serve out that particular, because there was a term. Yeah. Yes, Ted,
I was in Wisconsin in 2010,
I feel your pain.
and that's what happened. It was very political, and the abortion thing that you mentioned was very political. That was a major
Yeah.
campaign to elect a particular judge onto
Right.
that
Right.
court who would support the idea that you could have an abortion.
Right. Well, Wisconsin is still rocking and rolling,
Oh, yes.
because they are a 5-4 Democratic court at this point, but the MAGA is working very hard there's an election coming up. So I'm getting an almost daily appeal for contribute to defend the courts.
I'm on a couple of loops for
Yeah.
people I knew.
Yeah.
Well, and back to political in Washington, they will undoubtedly be having to deal with the fact that taxing millionaires might be unconstitutional.
It might be.
And as well as voting rights and LGBTQ rights.
Right. That's some of the population that I include in my comments about bending the arc towards, women finally having a new birth of freedom, but also LGBTQ who are stigmatized every time you turn around, and just like saying, are they dangerous? Is LGBTQ catchable? Is it infectious? And the answer is no. And let's think about all the Catholic priests, and I don't mean to disparage any, but many priests hid in the Catholic Church because of their homosexual latencies. and they abused boys and some abused, I mean, it was a way to hide from justice. And unfortunately, the Catholic Church aided and abetted that hiding. And you come across it in how children were treated, indigenous children in Canada, indigenous children here.
Wasn't just there.
Yes, Bill.
The state of California saw that, we saw that very seriously, especially in St. Louis County, not St. Louis County, but LA County.
Mhm.
You know, that what they would do is that when when a priest would get caught with his hand in the cookie jar, so to speak, they transfer him off somewhere else.
Yes,
You know?
right.
So it was a game of hide the pea.
Yeah. That was absolutely right. I forget the movie that was done so well by that. The Boston Globe and their
Spotlighter.
The Spotlight. That's it.
Yeah.
That was a great movie, and that's exactly the issue that their small group was investigating, and they found that it had happened hundreds of times. So there is yet a further and weightier reason, we're getting close to the end, guys, for the permanency of the judicial offices, which is deducible from the nature of the qualifications they require. It has been frequently remarked with great propriety that a voluminous code of laws is one of the inconveniences necessarily connected with the advantages of free government. To avoid an arbitrary discretion in the courts, it is indispensable that they should be bound down by strict rules and precedents, which serve to define and point out their duty in every particular case that comes before them. It will readily be conceived from the variety of controversies which grow out of the folly and wickedness of mankind that the records of those precedents must unavoidably swell to a very considerable bulk, and must demand long and laborious study to acquire a competent knowledge of them. Hence it is that there can be but few men in the society and women that have sufficient skill in the laws to qualify them for the station of judges. And making the proper deductions for ordinary depravity of human nature, the number must be smaller still of those who unite the requisite integrity with the requisite knowledge. These considerations apprise us that the government can have no great option between fit character and that of a temporary duration in office, which would naturally discourage such characters from quitting a lucrative line of practice to accept the seat on the bench, would have a tendency to throw the administration of justice into the hands of less able and less well qualified to conduct it with utility and dignity. In the present circumstances of this country, and in those in which it is likely to be for a long time to come, the disadvantages on this score would be greater than they at first sight may appear. But it must be confessed that they are far inferior to those which present themselves under the other aspects of the subject. Upon the whole, there can be no room to doubt that the convention acted wisely in copying from the models of those constitutions which have established good behavior as the tenure of their judicial offices in point of duration, and that so far from being blamable on this account, their plan would have been inexcusably defective if it had wanted this important feature of good government. The experience of Great Britain affords an illustrious comment on the excellence of the institution. Publius Valerius Publicola. That's why we need a Supreme Court. And that's why the Supreme Court ought to be the institution that determines whether something is or is not constitutional. And those things which are unconstitutional are forever null and void. Paul.
So I remember you've talked about all the character of the judges and how important that is and everything else. And I have a vague recollection that up until Robert Bork, judges tended to be damn near unanimously confirmed.
Yes.
And things have obviously gone way south since then.
Yes.
My question is, was that the case for most of the history of the country? That, in other words, it's only recently that we've started ramrodding judges onto the bench?
That is a fairly recent phenomenon. For the most part, it wasn't considered important enough to even worry about it.
Oh,
Not that it wasn't a prestigious position and not that some good lawyers didn't want to be on the court and never had the opportunity to be on the court, but it was generally that presidents selected non-controversial people skilled in their knowledge of the law and fair in their decision-making process. Robert Bork was clearly not of that mold. He clearly was an originalist, and he tried, and Reagan thought that he could force Bork down the throats of the Democratic Senate. And they said, no, you're not going to either. But then you have this thing, which is true. I used to use a political cartoon in my AP government class, and you had a Supreme Court sitting up on the bench, all 9 of them. All of them were Ronald Reagan. And what that meant was the influence that the president had over the Supreme Court was long lasting. And we had until when Justice Stevens stepped down in the early, well, maybe 2008 or something, he had been appointed by Gerald Ford. Think about the law from 1974. He was there for at least 40 years. And he was a Republican who said, my party left me. He said, I haven't changed. I still rule the same way, but now everybody says I'm a liberal. He says, I'm not a liberal. Yes, Betsy.
Questions.
Okay.
Maybe you've answered them and I forgot.
I did, so let's skip on.
Questions. The original colonists and the founders consider themselves citizens and decide that they
Well,
were suddenly citizens.
once the United States came into being, with some exceptions, everybody was grandfathered in.
Okay. The second one is what's the rationale of Citizens United? Talk about legislating.
The rationale of Citizens United was to try to allow unlimited money to unlimited, unchecked, dark money to enter into the
That
campaigns.
couldn't have been their right.
But that's
That's
No, they were saying, that's what they were doing. What they were saying is, we as American citizens ought to be able to contribute our money to political campaigns. And that corporations ought to be seen as people, therefore corporations can also put money into the political systems.
So it's
That's what they were saying. Yeah, and it is one of the direct causes of some of the issues that we have today, where you have dark money that is unchecked. You have no idea where it's coming from.
Lots of.
And it can be Russian money. It can be Chinese money. We have, as Americans, we have this nasty tendency to be easily corrupted.
But how did they base that on the Constitution? And because I haven't read
They
it.
didn't.
Well, it's been a long time since I've read that decision, but President Obama was right in saying that it was unconstitutional. And that's where the one congressman, you lie. That's the first time somebody during a State of the Union shouted out, you lie. Joe something or Joe Mama, probably.
But it was considered freedom of speech.
Yes, that was the issue.
Money was equated,
Yeah.
making your.
Yes, right.
Like,
Yeah, money is free speech that's the essence of it. Yes,
So if you have someone on the Supreme Court who really turns out to be a bad egg,
yeah,
is there a way of getting rid of him?
Impeachment. Impeachment is it.
And has.
Or pressuring them to resign. Yes, justices have been, not many Supreme Court justices. And keep in mind, a week ago, I talked a little bit about that because Justice Samuel Chase was impeached, but Jefferson didn't just want to get rid of Samuel Chase. He wanted to chase, so to speak, off all of the Federalist judges on the Supreme Court, particularly John Marshall. So Samuel Chase was just an intermediate goal. It failed, though. That impeachment of Samuel Chase failed, and that protected John Marshall. and basically enabled him to become the great Chief Justice that he became. Yes,
Well,
I'll get to you, Ted.
what's the impeachment of a Supreme Court justice? Is that a 50-50 thing, a 51-49 thing in the Senate, or what is it?
Yeah, no, it would be 2/3.
2/3.
If a justice is put on trial, the impeachments, he's impeached in the House, tried in the Senate, but it's a 2/3 bar that has to be met. And with the Jefferson Democratic Republicans, even though they had a majority, even though they had a 2/3 majority in the Senate, some of the Democratic Republican senators said, no, this is going too far. Can't do it. Ted.
I did something I don't normally do, and that was last night I watched the opening, the first one of the month of
Count 'em on,
Count
count 'em
Monte
on,
Cristo.
Oh, right.
And that has something to do about what you were talking about in here about being put in jail
Yeah.
without court.
A bill of attainder,
Yeah,
right?
And so that had to do with the court, the king and Bonaparte.
Right.
And then I watched all of those Thomas Jefferson things on this damn program called PBS, you know.
Yeah.
Damn liberals.
Yeah.
Anyhow, and so in the middle of that, they say he wrote a letter or an article or something that says that blacks are not equal to whites. He said that. And although he
Oh,
was,
I know Jefferson, you mean?
yeah, Jeff,
Yeah, it's in the Kentucky resolutions, I believe is where you find that.
and then you talked about the Seneca Falls and what's his name, Adam's wife writing.
Yeah, Abigail,
things like
yeah.
that. And so I've been in Seneca Falls and things like that, but I may be doing sometime in the near future, a play called What the Constitution Means to Me. And it has to do with a woman's view of what has happened to the American women all the way through. So I may be doing that.
I can help you with that, Ted.
And
Where did you get your
yeah.
ideas?
You know, so
And
He's gonna explain what.
definitely get a copy of definitely get a copy of Elizabeth Cady Stanton's Declaration of Sentiments.
can I have that?
You may certainly have my copy.
So anyhow, but then since then, we've had to not produce again the 12-member It Can't Happen Here cast that we had because we couldn't get everybody back together.
Mhm.
Indivisible Squim wanted to do it again, but we didn't. But since then, I've received a 6-member cast, and I'm known as a guy in Bainbridge who's writing a four-person. And so things like that are coming at me, and I'm going to try to do as much damage to all this as I possibly can while I'm still
Good on you, Ted.
do it. And then let's see. I was in New York in the 90s when the 20-year anniversary of Thomas's election to Congress.
Yeah, elevation, yeah.
What was the woman, the lawyer that was against?
Anita Hill.
So I listened to her talk at the university where this was held. There for 3 days, you know, and it was going on. And it's really interesting what goes on.
She was telling the truth.
I'm walking around with this AAUW pencil here in my pocket.
Yeah,
But anyhow, you think you're gonna vote in 2026?
we're hoping. But you can't, again, if I'm expecting the Supreme Court to save me,
No, it's not.
track record says,
Make me want to cry.
yeah,
Part of Cascadia, the new state, the Cascadia.
yeah. Yes, John.
What was the situation regarding interstate commerce before Marbury versus Madison? And what did that solve?
Marbury versus Madison was not an interstate commerce decision. That decision was what enabled that's where the Supreme Court, using the logic of Alexander Hamilton, established judicial review. William Marbury, who was given a position of justice of the peace. It's not like it was a Supreme Court justice. Madison refused to deliver it because it wasn't delivered before midnight of the day that Jefferson would have taken the been inaugurated. So William Marbury sued. Well, that put John Marshall in a really difficult position, and Jefferson thought he had him. He said, no matter what, how he rules, I got him. But Marshall outsmarted him and said, yes, William, you should deliver that justice of the peace to William Marbury, except for this one small problem. The 1792 law that created that position is unconstitutional. So so Jefferson wins, but he loses because now the Supreme Court has declared what he wanted to do unconstitutional. So, and poor William Marbury doesn't get the justice of the peace, but Jefferson doesn't get his way either.
And that's the first time that happened.
That's the first 1803, first time that happened. Now, as far as interstate, well, you've got a number of interstate commerce things, but yes, Paul.
I just want to let you know that in the chat, you have Marie and John Mars and Maya all thanking you profusely for having done a wonderful job here.
Well, thank you. I appreciate that.
My knees weren't so bad, I'd stand up.
Well, stay sitting. I don't need a standing ovation, but thank you so much. Yes, Lynn.
I just thought, probably 20 years ago, I read a book called The Brethren.
Yes.
Bob Woodward.
By Bob Woodward. He had a co-author, Stephen something or other. It's a great book.
It's a fascinating book on, is it the Brennan Court?
Yeah, it would be the Burger Court. The Burger Court.
I mean, just a fascinating read
Right.
of a certain time period of
Right.
the Supreme Court. If you like that kind of stuff, it's really, really well written.
And a follow-up to that, I highly recommend The Brethren. It's of a different age.
Yeah,
It really is. Jeffrey Toobin's The Nine. Read Jeffrey Toobin's The Nine, which is 3-4 years ago, maybe, but same thing. And you see, if you know both books, you see the dramatic difference in the way the court is politically operating versus when it was under Warren Burger. And Warren Burger was kind of a so-so Chief Justice. One of the Minnesota twins, because Harry Blackmun was also the author of Roe v. Wade, was also from Minnesota. And observers stupidly expected them to act alike, and they were shocked when Harry Blackmun turned out to have a mind of his own.
Oh, no.
Yeah. And Linda something or other from the New York Times wrote, Becoming Harry Blackmun. That's another good one on the Supreme Court to read. Linda Greenstone? Greenhouse, that's it. Yep. Becoming Justice Blackmun. Becoming Justice Blackmun, I think is the title of the book. Excellent book. I've read widely on the Supreme Court and
I can attest to them.
Paul.
So I have a question throughout, as you've been talking about these things and terms and separating and from the people and so forth. So they use a lot of language that says, we want to reflect the will and everybody's free and blah, blah, blah. But then they say, well, we want to get these things as far away from the people as possible.
There is that.
Like the impeachment in the Senate and the courts. So what is
Election of senators by state legislatures.
Right. And so that's my question is, did they pay a lot of lip service to the people while at the same time being kind of like Mel Brooks? Oh, the people are revolting. You're damn right they're revolting.
Yeah.
It's nothing to do with them.
No, there's a lot to be said for that in theory, the people held the political power, but in practice, the political elites did not trust them. And there are a lot of reasons not to trust them.
As we found out this time.
Yeah. And there are reasons to trust them. But that's why Jefferson was, an educated populace was supremely important. Lincoln said exactly the same thing. You need an educated people so that they understand the decisions that they're making and are rational and just.
Can I recommend one other book?
Fire away. We're all about books here.
It's called Dark Money. Do you remember the author?
Yes, Jane Jane Meyer. Yeah,
It's a fascinating book about how money is
yeah,
moving our country around.
yeah. Sad. The stories are horrifying about the amount of money and who's moving it. Yes, and she's 100% on task and on target.
One other question that popped into my head.
Okay,
So relative to these corporations being people and blah, blah, blah.
that's a huge mistake, Angela.
I have been under the impression that way back at the beginning, that in order to form a corporation, you have to actually say, this is a public good, such as building the Erie Canal, that takes more money than any individual would have, but we want the thing done for the public good. So therefore, we will allow you the limited liability and all the other stuff that goes with being a corporation, but you're supposed to be working for the public good.
Right.
What happened to that? And can we bring it back?
Called the almighty dollar. Profit motive.
And look what happened.
And people, and many people with a lack of virtue.
Mm-hmm.
The fact is, Washington, the founders said this system depends upon virtue. If the people lose virtue, the system cannot survive.
Right.
A great example of that. Yes. Yeah, but they had no idea they were being experimented upon. Yes, Ted.
How about whoops?
Huh?
Whoops.
He didn't live here.
He's from Ohio.
Oh, yeah, no, I'm from Ohio. We're the genuine whoopsies.
Whoops, guy from Olympia out to Aberdeen and off to the south, there's all these towers that sort of go up. There was for a nuclear plant that was supposed to.
Oh, I've seen that, and I get only in your state every day, which I like to places to go to, and they pointed that out as a place to go to.
That's quite a story about whoops.
Yeah. Okay. Yeah. Now I know what you're saying.
Oops, he's talking about.
Yeah, I do know what whoops you're talking about. Yes.
The Supreme Court has no code of ethics.
Well, they do. It's non-binding.
Do you ever think it'll be changed so that they're actually?
Not by them. It's going to have to come from a liberal Congress. It's going to require a Democratic Senate, a Democratic Congress, and a Democratic president to establish those guidelines and make them mandatory for Supreme Court justices. Other than that, it's not going to happen.
So there's been some sort of discussion of Supreme Court justices and their terms that they might not be lifetime, and maybe to even it out so that every president gets to put a guy or two on the bench. Do you think there's any chance of that happening, or?
Because it requires a constitutional amendment.
And that ain't gonna happen.
Which requires 2/3 of the House, 2/3 of the Senate.
And a whole bunch of states.
And 3/4 of the states. And so it only takes 25% plus one to block it. And small states will not see that in their best interest. So not only do you have GOP states would not like that idea, but small states with low population like Wyoming and so forth, they also are not going to go along with it because they see it as a power grab.
Is it a constitutional amendment to expand the Supreme Court?
No, that can be done by law. Yeah, if you read the Constitution, there's a lot of ability that it gives to Congress. So Congress created the federal district courts, Congress much later created the appeals districts. So, and Congress can control the number of justices on the Supreme Court. They can control their salaries, but with the restriction that once a justice is receiving a certain salary, it can never be reduced. So they can reduce it for future justices, but they cannot lower the salary of a sitting judge, because then that judge becomes a target. Yes, Bill.
They can turn their office into an outhouse, but these kids.
That's correct. Anything else for the good of the cause? Thank you so much, everybody. You guys are terrific.
Maybe in the fall or something.
Well, we'll work on that. I'll have to work with the Education Committee, to whom I owe a deep vote of gratitude, but we'll work out something.
I actually have another comment.
Okay.
A question in the thing that says, can you please comment on the law of privacy, which is not mentioned in the original Constitution?
Okay. That takes place because of the Ninth Amendment, which says, even paraphrasing, even though we didn't enumerate it, which means state it, doesn't mean you don't have it. So the law of privacy, that's called a penumbra, by the way, is the name that they give to those things that are in the rights that you have, but may not be written down in the Constitution. And that's found in the Ninth Amendment. Just because we didn't state it here doesn't mean you don't have it. And it applies to states as well.
Good. Well, thank you very much.
You're very welcome.
Oh, snap.